Good morning, good afternoon, Judge Savage. Please switch on your mic so I can hear you and everyone can hear you.
Good afternoon, Chief Justice and Commissioners.
How are you this morning?
I'm well, thank you.
Thank you. Thank you for availing yourself for this interview, for consideration for appointment to one of the positions in the Labour Appeal Court. I will ask you questions, and some of the commissioners will also ask you questions. We will do so to try and satisfy ourselves how you fare when we look at your track record and your knowledge and experience against the selection criteria that we have adopted for the selection of judges. We might be robust in our questioning, but we don't mean to humiliate you or anything of that kind. You hold 3 degrees, is that correct?
That is correct, Chief Justice.
BA, LLB, and LLM.
That's correct.
I see that after LLM it says summa cum laude. Is that for all the degrees or
no,
for the LLM?
That's for the LLM.
Oh, that's quite good. And I see that you are enrolled for the PhD in public law at UCT.
That's correct,
Since
Chief.
2020.
That's correct, Chief Justice.
How far are you from finishing your thesis?
Not as far as I would like.
Not as far as you would like.
No.
It's work in progress.
Work in progress.
Okay, all right. And you got your BA and LLB from the University of Cape Town, and your LLM you got at the University of Notre Dame.
Yes, that's correct, Chief Justice.
Is that right? Okay. You practiced as an attorney for some time, is that correct?
Yes, that's correct, Chief Justice.
How long did you practice as an attorney?
So I did my articles in 1992 and 1993. I was admitted in 1994, and I commenced practice then as an admitted attorney in January 1994, and I continued on. I then started my master's degree in August of 1994 and came back to South Africa in December of 1994. And the reason I then broke my master's degree in half, and I came back to work for the ANC and Parliament on the constitutional negotiations. I then completed the master's in 1997. And after I'd worked for the ANC and Parliament for the Constitutional Commission of the ANC, I then was employed by the Constitutional Litigation Unit of the Legal Resources Centre in Johannesburg. And I worked there until I was then appointed at the CCMA as a commissioner until in 2000. And when at the end of 2000, I then started in practice again. So I've essentially remained working in the legal field all through from my admission as an attorney, and for many years as an attorney in practice.
Yes, but it looks like actual practice, you would go into practice for a short period of time and then go and do something else and then come back. Is that right?
It was really only the period from 1995 that I was working for the ANC, then went into practice again at the Legal Resources Centre, and then worked for the CCMA. But from 2000 then until my appointment as a judge, I was in practice.
Yes. And do you want to share with the Commissioner the nature of the work you did in your practice, how diverse the work was in terms of different branches of law?
Well, when I was employed at the Constitutional Litigation Unit of the Legal Resources Centre, my work was involved only in constitutional litigation and also in the certification of the Constitution. So I was involved in the certification of the Constitution case. And then when I left, and then all other constitutional related matters. I left the LRC and went into practice in 2000. I was then working, doing a lot of labour law, but some civil litigation as well. I did a couple of bail applications. I did some civil litigation, and and a lot of labour law. Yes, I was also an arbitrator and a mediator from 1990. Certainly from 1994, if I remember correctly. Might have been slightly earlier.
Was your practice as an attorney largely a labor law practice?
Yes, with some civil litigation, some mainly public sector litigation involving tender reviews or things like that later on. So much, it was civil litigation. It was certainly not criminal.
Yes. Okay. And you acted in the labor court in 2011, is that right?
That's correct, Chief Justice.
Well, that was from some October to December.
Yes, that's right.
And then you acted also in the Western Cape High Court from October 2012 to 31 December 2014.
That's correct.
That was quite a long acting stint.
9 terms, and I applied for appointment and I went through the JSC in 2013. There was one position available in the Western Cape, and I then remained. I didn't get it, and I was remained on as a judge in the Western Cape, as an acting judge in the Western Cape. And I then applied on the next occasion, and I was appointed.
Did your acting stint, that long acting stint in the High Court, help to expose you to other branches of law that you might not have had the benefit of getting exposure in your private practice?
Absolutely, in many and varied ways.
Yes. Are you able to share with the Commission what kind of branches of law you got to deal with when you were acting in the High Court? Well, actually, you can go on to tell me also after you had been appointed to the High Court, because you were subsequently appointed.
Yes, I mean, well, throughout my period at the High Court, I've been involved in all branches of law, from criminal trials, criminal appeals, criminal reviews, civil trials, civil appeals, civil reviews, administrative law, insolvency law, the law of contract, numerous and varied areas of law.
Were you appointed to the High Court with effect from 1 January 2015?
That's correct.
Yes. But it looks like you didn't take long after being appointed to the High Court that you got an acting stint in the Labour Appeal Court in 2015, same year.
That's correct, Chief Justice.
Is that right? The questionnaire here reflects that you acted in 21 terms. You acted for 21 terms. Is that true?
That's correct.
21 terms is a long time.
Yes.
That's how many years?
This is the 8th year. This is the 8th year that I've been acting in the court.
Yeah,
so
but your question
says it's 21 terms.
So it says 21, or that's up to 2023.
Yes.
Okay. How come you didn't avail yourself for appointment to the Labour Appeal Court earlier rather than acting for so long?
Because there have been no positions advertised, Chief Justice.
Oh, this is the first opportunity you had?
That is correct.
Okay. How did you find work in the Labour Appeal Court?
I've really loved it, the experience of working in the Labour Appeal Court. I enjoy appeal work immeasurably. I have learned a lot from my colleagues there. It's a very collegial court, and I've found the experience that I've gained there to be invaluable to me, both in that court, but also when I've returned to the High Court in my practice there, in my work there.
Normally, as I understand the position, and the JP will tell me if it has changed, normally if you got appointed to the Labour Appeal Court as a judge of the High Court, the position would be that you would serve in the Labor Appeal Court for some terms and then go back to the High Court and also serve there. You serve in both courts. Is that what has been happening? Is that what will happen, or will something else happen that is different?
I can't say what will happen, but I know that that has been happening to date. I've been on average serving 2 terms a year in the Labour Appeal Court and then 2 terms in the High Court. But going forward, I'm not sure what the arrangements will be.
The arrangement will be between the 2 JPs, but obviously they will hear what you have to say.
That's correct.
But
hope so.
you are happy to serve both courts in the way that it has been happening, if that is what is going to happen.
Yes, I certainly am.
Yes. Okay. Now, what can you tell the commissioners is your understanding of different schools of thought about the debate about the jurisdiction of the Labour Court and of the High Court in regard to certain matters where they have concurrent jurisdiction? Sometimes the Labour Court has exclusive jurisdiction. What are the debates? What are the different views that the various schools of thought have?
Well, the Labour courts have an unfairness jurisdiction, and then in terms of, so an unfair dismissal dispute jurisdiction, and then also have, in terms of Section 77(3) of the Basic Conditions of Employment Act, have a concurrent jurisdiction with the High Court in relation to contractual matters. So as far as the unfairness jurisdiction is concerned, that is established in terms of the Labour Relations Act, and in terms of the concurrent jurisdiction with the High Court under Section 77, that's established in terms of the Basic Conditions of Employment Act. However, the problem has arisen in relation, and it has risen over some years, in relation to claims that have been brought in the High Court of unfair dismissal in certain circumstances. And that started, and it was probably also before, in cases such as Chirwa, Fredericks, Gaba, and others, where an unfair dismissal claim was brought to the High Court, often by public sector employees arguing that the provisions of PAJA applied and that they were entitled to bring the case in the High Court. And over a period of time, those cases found their way to the Constitutional Court, and it was determined that the Labour Court held the unfair dismissal jurisdiction. Following this trend in cases, in more recent times, Edcon and Steenkamp was a case that emanated, again, out of the Constitutional Court, which was dealing with the unlawfulness of a claim of unlawfulness in relation to a dismissal, a termination of employment complaint. And what in that matter had occurred was that there was a notice issued in terms of Section 191A, in which the employee claimed that that notice was unlawful. And the matter in the Constitutional Court, it was determined that the Labour Court lacked an unlawfulness jurisdiction, and therefore that there is a distinction when cases are brought on the basis of lawfulness and basis of fairness as to which court one may approach. That, of course, has posed some problems because, and I think that it will continue to wend its way through our courts as we try and resolve exactly what the ambit of the difficulties that such a configuration then creates. For instance, in a suspension dispute, there might be an unlawfulness allegation, and does the Labour Court in that circumstance have jurisdiction or not? And there have been different views that have been expressed by judges in respect of these sorts of issues. But certainly as the law stands at the moment, unlawfulness and fairness are dealt with differently in our courts, and in terms of the jurisdiction of the Labour Court, the jurisdiction has been made clear because it is, after all, a creature of the courts established by statute.
Of course, you say that some public sector employees take unfair dismissals to the High Court. They don't take them as unfair dismissals, do they? They take them as alleging that they are administrative action and so on.
That's
or
correct.
That their constitutional rights have been infringed. Is that right?
In some instances, there have been claims of unfair dismissal, but obviously in others, the claim is not an unfair dismissal claim, it's a contractual claim, and one brought under PAJA.
Yes. And What can you share with the commissioners with regard to the different schools of thought on the applicability of the Prescription Act to labor disputes such as unfair dismissals?
It's another area in which we have many judgments of our courts in which there have been different views expressed by different judges, and often not always in a manner which has allowed for the issues to be determined unequivocally and finally. And unfortunately, certain of the judgments of the Constitutional Court bear this out. I mean, I sat in the Labour Appeal Court in the matter of Hendor, and that decision, with two of my colleagues, that decision found its way to the Constitutional Court in respect of prescription. And in the Constitutional Court was a decision, a 4-4 split in that court, and so but it seemed that the common thread through the case was that the view was that the Labour Appeal Court had been wrong in relation to its treatment of prescription. In more recent times, we've had cases such as Pyman's Pantry and Coca-Cola. And in the Pyman's Pantry case was concerned really with the referral of an unfair dismissal dispute and whether what the relationship between the Prescription Act and the Labour Relations Act was in relation to the referral of an unfair dismissal dispute. So, for instance, could you refer a dispute up to 3 years, which is for purposes of the Prescription Act, you would be able to refer it and then seek condonation. And the decision of the court appears to be that that is so, that the Prescription Act applies and that one may then seek condonation. So that to the extent that if the claim is a debt, you're entitled to then approach, to refer the matter on that basis. In respect of Nyataza and Coca-Cola, well, Coca-Cola concerned the certification of an award and whether the Prescription Act applied to that certification, and it was found in that case that the claim had not prescribed, so the application for certification of the award had not prescribed, and therefore the Prescription Act would apply, and that meant that one had 30 years within which to approach the court. Nyataza is a more difficult case to follow, but essentially seems to be the same in respect of a judgment debt that the Prescription Act does in fact apply.
Well, thank you. What's the difference between a sympathy strike and a secondary strike? Well,
a sympathy strike seems to me to be a case in which different industries go on strike in sympathy with with a primary strike, and a secondary strike, as I recall, is different in the sense that it's a strike in a similar industry where one has a secondary strike in that industry. I may be wrong.
Yes, isn't there something with regard to a secondary strike that you must say about a demand?
Oh, absolutely. In the secondary strike, one has to serve a demand. There has to be a demand in a secondary strike.
Yes. And a grasshopper strike?
A grasshopper strike, as far as I recall, is where one is having different strikes at different plants in the same sector.
Just repeat that answer.
Different strikes in different plants, so that one has, let's say, in a company, one would have different plants on strike at a different, as it would be a grasshopper strike, as far as I recall.
Mm-hmm. If you are appointed to the Labour Appeal Court, you will be hearing appeals against judgments of the Labour Court. And at some stage, you might have to deal with decisions of the Labour Court judges where they exercised some discretion in making a decision. Are you familiar with the two types of discretion? If you are, would you tell us what they are and what the legal significance is of the differences between them?
Yes, there are two types of discretion in our law. One is a true or narrow discretion, and the other is a wide or a loose discretion. And in respect of a true discretion, the judge may take, in exercising that discretion, may take any one of a number of permissible routes. And those routes, the decision to take one or other of those permissible routes, cannot easily be interfered with by a court on appeal, and there can only be a set aside where the decision has not been taken by a judge exercising his or her discretion judicially, or where that judge has been influenced by wrong principle, or where there's been a misdirection of the facts, or where there's not reasonably, on a consideration of all relevant facts, it really falls quite far out of the bounds of the discretion. So capriciousness and so on might also come into it. A wide and a loose discretion, on the other hand, there's no choice between equally permissible options. And an appeal court can therefore interfere really on the basis of correctness. It can take a different view to that taken by the judge.
Yes, thank you. I will now give the JP the opportunity to put questions to you. JP?
Thank you. Thank you, Chief Justice. Good afternoon, Ms. Savage. Tell me,
Good afternoon, Judge Watley.
when you talk about correctness, is there any particular area where correctness would apply on review rather than the narrower discussion or the wider discussion?
In a review situation, for instance, in a constructive dismissal, or
I can't hear you.
in a constructive dismissal case, perhaps, or I'm not sure in what context you're referring to.
What test will apply, the narrow or the...
In respect of a wide, sorry, I'm not.
Where there is a
perhaps you could
decision
repeat your
made by
question.
the Labour Court,
Yes.
if you talk about a constructive dismissal case, and it applies, the Labour Court exercises the discretion on whether the dismissal was fair or unfair, let's say that. It comes up to the Labour Appeal Court. What do you look at? Would that be, would you now look at correctness of the decision or not? That's one example. Another example would be where the court decided that it had no jurisdiction to entertain that matter. It exercised your discretion to say no jurisdiction. That comes on appeal. Would that be what test? Would the correctness test apply or not?
Yes, I mean, it would be a correctness test.
I can't hear you.
It would be a correctness test.
Might be a correctness test. Okay. I've noticed that you've been, you've acted, you've been in the Labour Court, you're permanently in the High Court, you've acted in the Labour Appeal Court for a while, you've acted in the Competition Appeals Court, you've also acted in the Supreme Court of Appeal. Now, with regard to all these acting stints and all the work you did, would you agree that the notion that the Labour Court is a very restrictive field, a limited field, or at least the Labour Court exercises jurisdiction in a very restrictive and limited field? Or would you say, after 8 years at the Labour Appeal Court, that it is in fact a court where all sorts of law is involved, that when you sit in the Labour Appeal Court, you don't just have straitjacket Labour Court, labour law matters, but you have matters dealing with admin law, contract law, commercial law?
Yes, that's correct. There are a number of issues that come into play in labour law. And those are not only contract, also administrative law, also public sector issues that come to play. And I am firmly committed to the importance of the labour courts and their functioning, because I believe very, very firmly that an efficient and fair functioning of labour relations in this country is important for the development of the labour market, important for economic growth, and important for employment creation and poverty reduction. All of these are really important aspects. The importance of having a functional labour court cannot be understated in this country. That is my view. And it is an area of law in which, given the fairness and equity, the sort of mandate under the Labour Relations Act, it's one of the areas of our law which I find is very much, it's closely related to the way in which I like to approach things in this country. And that is that one needs to seek greater and greater one needs to strive increasingly to seeking fairness and justice across our society in many, many different areas.
One of the issues that I think judges, and all judges, including the High Court, are now facing is because of cost-cutting measures and all the other measures dealing with finance, is the ability to afford law reports. And tutors has become so expensive. Now, I understand that you sit on the board of SACLI. Can you tell us how does that assist us in any way, at least the judges and the courts?
How long do we have?
You've got a minute and a half.
I've been very centrally involved in the creation of SAFLI over the course of about 15 years, from when it was at the Constitutional Court, and then we moved it to the it was associated with the Library of the Constitutional Court. I was on the Constitutional Court Trust at that time, and we, as a trustee, and we were very involved in setting up SAFLI. I'm very, very passionate about SAFLI as a project, and I put a lot of my free time into SAFLI. I believe that it serves an important purpose, not only in ensuring access to justice by ordinary members of our society, but also it serves a very important role in advancing the rule of law through accessing judgments, but also in judicial accountability issues. I am concerned that our contracts with the commercial law reports have been curtailed in some way. I'm not entirely au fait with where we stand on those issues. I have concerns that they cost the state an enormous amount of money in circumstances in which the state judges are in fact the authors of much of the product. So that there are difficult issues that arise in relation to commercial law reports in terms of what type of money is made available to access those law reports. I am concerned, and I do know that judges all access SAFLI, but I am somewhat concerned that there is increasingly less access available to other law reports, given that we in SAFLI simply do not have the funds to have head notes and to have the sort of add-on products that are available in the commercial law reports. We're also not able, and we don't have the funds, to involve ourselves in noting up judgments, although we're trying very hard to try and see whether we can't do that. The moment what we're trying to do, and our main role is, our main task right at the moment is to ensure that we've got a full set of law reports. And most recently we've added the law reports that date back to the 1890s, right up, and we've got some gaps. We've got a lot of Supreme Court appeal law reports in prior AD, so we've spent a lot of effort in all of those law reports. But there is still a role for commercial publishers and access to commercial reports.
Thank you. I see on page 8 and 9 of your questionnaire, you list the full list of your publications, which is quite a comprehensive list. It goes on, I think, right until page 11. Do you still write
No,
articles?
I don't really write. I write judgments now. I have had 3 children, and I haven't had a lot of time to write.
Thank you. And one last thing I want to ask you is, following up from what the Chief Justice asked you, if there is a need that, or there's a decision or need that labor appeal court judges are required to be full-time in the labor appeal court, would you then decide to go back to the High Court, or would you be happy to stay at the labor appeal court?
I would, on my feet, I'd be happy to stay in the Labour Appeal Court, but I would like I would like the issue to be discussed with me and to understand the precise terms on which I would then depart the High Court, if that was possible.
Thank you. No more questions, Chief Justice.
Thank you, JP. Minister?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Minister.
I see you have also worked, in addition to your work with the SAFLI, which is commendable. You are also working or worked with the National Community-Based Paralegal Organization that works across the country
Yes.
for access to justice. Why do you think this work on access to justice, firstly with SAFLI and with this paralegal organization, is important for our constitutional democracy and for access to justice by members of society, and in particular the vulnerable in our society?
Excuse me, I missed the last part of your sentence.
In
Minister.
particular the vulnerable in our society.
We live in a really deeply divided society, and one in which we have the unfortunate label of being one of the most unequal in the world. And for me, that is and the legacy that we come from in terms of our legacy of racial discrimination and our legacy in terms of the kind of poverty, the extent of poverty and lack of access faced by so many of our people, of South Africans, at all levels, around the country. These are issues that throughout my life have always worried me. I grew up in a family in which these issues were issues of concern for our family, and I continued in my days as an activist at UCT when I was there. In my work as an attorney, I've always been involved in cases that have been centrally interested in human rights and access to justice. I remain still firmly of the view that we need to ensure that people always have access to the law in order to be able to resolve their disputes, in order to be able to understand their rights, in order to be able to exercise their rights, and able to, in fact, realize those rights to the greatest extent possible. And we have so far to go in all of those areas. And that makes access through paralegals and through lawyers around the country so enormously important for so many people.
Thank you, CJ.
Thank you. I have already got 7, but I've included myself. So I'll exclude myself and put Commissioner Matolo Zep. Okay, thank you. Justice Molamela.
Thank you very much. Good afternoon, Justice.
Good afternoon, President.
I note that you acted at the SCA for 1 term.
Yes.
And that you delivered a judgment there. You penned a judgment, engine petroleum versus flow tank transport.
Yes, that's correct, President.
I read the judgment. I noted it was marked reportable and that it was handed down within a month of the date of the hearing, which is good.
Thank you.
My question to you is, do you think that acting at the Supreme Court of Appeal gave you exposure? And if it did, what kind of exposure did it give you? And do you think that that exposure will stand you in good stead at the Labour Appeal Court? And if so, how?
Yes,
Thank you.
Thank you. I acted for 1 term. I was in fact asked to act for 2, but I was unable to make the 2nd term given that I had my long leave due to me and I had decided I was going to work on my PhD. So unfortunately I was unavailable for the 2nd term. However, the experience was absolutely invaluable to me. It was really, I brought, I think, my experience in the appeal court that I had as an acting judge for so long in the Labour Appeal Court to the Supreme Court of Appeal, and I found that useful. It certainly gave me some confidence in dealing with appeals. It did take a little time to get used to the different ways and of operation of the SCA, but the range of work was very exciting, and I found it quite very interesting and enjoyed it thoroughly. I certainly think that I gained a lot from it, both in seeing sort of across different areas of the law, how one's similar approaches to the work of an appeal court, in fact, they're shared, there are similarities that are shared. Yeah, I think that have I missed a part of the question? I think that might have answered the question. Did I miss
Yes,
it?
how would that exposure assist you if you were to be appointed to the LAC?
Yes, I think that exposure has definitely assisted me. It's a very rigorous, often process sitting in the SCA with a lot of debate that is with judges expressing firm views one way or the other. And that I found very useful and interesting, and I found myself comfortable in that space. And it's certainly something, the Labour Appeal Court is often not as vigorous a debate, and I certainly think that I bring with me back into the Labour Appeal Court that experience and the experience of my colleagues in the court that don't work in Labour areas, but from which I learned an invaluable amount. Thank you.
Thank you, Chief Justice.
Thank you. Commissioner Marumohai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
When I went through your CV, I saw that you wrote one of probably the most important judgments in a panel of 3, the Campbell Scientific Africa versus CIMER.
Yes.
that dealt with probably one of the most sensitive issues in South Africa, which the issues around it are never discussed fully because of the sensitivities around it. I just want to pick a brain with you, because on the one hand, we find that there are employees, once they are accused of sexual harassment, they resign. And you find that the matter sometimes dies there, despite the importance. And it is not dealt with accordingly as it should. On the other hand, there's a debate that says sometimes you see that sexual harassment is used as a tool to get to deal with other employees. Where is the South African law at currently, and is our law striking an appropriate balance to allow us, one, to have frank discussions around the issue with a view to ensure that we find lasting solutions on how to deal with sexual harassment in the workplace?
Of course, in the context of labour law, if somebody resigns, then one in fact doesn't have any further jurisdiction over them in terms of discipline. So that's a difficulty that's somewhat poses some complexity in the sense that one could have serial sexual harassers, and a person who's a serial sexual harasser moving from one workplace to the other without ever having been found to have committed sexual harassment. But as far as the sexual harassment is concerned, I know that in respect of that judgment, I was criticized in an academic article for setting the bar so low in sexual harassment that one could not help but trip over it. Well, if that is so, then that bar is already so low for women in the workplace. And what this judgment does is try to set quite clearly that when a 24-year-old woman goes to work in a foreign country for a company with South African colleagues, she is not fair game who can just be preyed upon. And that under any circumstances, and it doesn't matter what is said. We got into a lot of debate in that matter about, well, what was said was all very insignificant and trivial. It's really important, I think, to set quite clear guidelines as courts as to what is acceptable conduct in the workplace. If we're going to change a culture in which women can access work and the workplace properly as equals, then we need to make sure that we really do make that an equal environment. As far as people, of course, there's always a problem of people coming up with bogus complaints. One can't stop people coming up with bogus complaints that have no merit. In different workplaces, humans are complex and varied, and some have different kinds of problems, and they can be men and women and face those problems. So I'm not too sure that the law can necessarily stop that. But of course, what we do in all cases is ensure that when somebody's accused of sexual harassment, one looks carefully and properly at all of the facts that are relevant to the matter and doesn't just jump to conclusions that because I'm female and a judge, I'm going to find everybody guilty of sexual harassment. Quite the contrary.
Thank you very much, Judge. Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon to you, Judge Savage.
Good afternoon, Commissioner.
Mine is just an observation, Chief Justice. And
Okay.
since you come from the labor court environment as well,
Yeah.
it would seem that only visionaries and prophets apply in the labor court environment. And I'm saying this from an informed basis because when I look at what Judge Botlale said in 2016, the last thing that he said to this commission when he was questioned on whether he would be lost to the labor court environment, he said, one of my visions at some point is that the judge president in the labor court may invite me to sit in the LAC, and then I can take even the experience that I acquired in the labor matters to deal with them at the labor appeal court level. And that was said 7 years ago. And Ms. Savage, then, when you were interviewed in 2013, this is what you said. I am now so comfortable in the High Court that I don't believe I would seek an appointment in the Labor Court. And that does not, of course, in many years to come, necessarily bar me from further involvement in the labor sphere. If it were in my future career possible to serve on the appeal tribunal involving labor matters, I would be prepared to do so. But that is far too far in the distant future for me to say. But that distant future has come for you 10 years later. I just thought I'll make that observation. Thank you.
Thank you, Commissioner Singh.
With grey hair, Commissioner.
Judge President Mlambo.
Thank you very much, CJ. Good afternoon, Judge Savage.
Good afternoon, Judge President.
I believe that me and you will be on a panel in a month to come in the LAC.
Yes, I think so. In Cape Town, if I'm correct.
Yeah. Well, I'm taking advantage of this since we're talking about SAFLI. You say there's a continuing role for commercial publishers, but isn't it correct that SAFLI publishes everything? Commercial publishers are selective.
That's correct.
Now,
We want to publish everything. Some courts don't send everything, and that's something we're working on.
I see. Are you aware that the CJ has a committee that's looking at judicial law reports in South Africa?
I had heard so, yes.
Would you be interested in bringing to bear or to that committee your expertise and experience at SAFLI to assist the judiciary not to reinvent the wheel and see what can be done to come up with a fully functional judiciary law reporting structure?
I would leap at the opportunity.
I see. Well, you got me into trouble regarding SAFLI in a different matter, which I'll take up with you offline. Thank you, CJ.
Thank you, JP.
Judge President, could I just add one tiny little addition, and that is just to mark, if the issue is SAFLI, that we are sitting with a problem in relation to legislation, and that it might be something that the judiciary is interested in.
Thank you, Commissioner Matolo Lepu. Subject to those on the platform, she should be the last one.
Thank you, Chief Justice. It's actually a follow-up on the issue of SAFLI. I wanted to know, I remember about 2 years ago, LPC undertook to fund
Yes.
partially SAFLI. And so far, how's the relationship now? Because I haven't read anything about
We
it.
have been enormously lucky because the attorneys' profession as well as the bar have come to the aid of SAFLI. And so currently where we stand is that the attorneys' profession gives us some money every year on an amount that is budgeted that they believe is an appropriate amount to give to SAFLI. And then we have developed a somewhat unusual, but a model which has worked really well, which is that across the GCB has agreed that every senior member will contribute 80 Rand per month to SAFLI and junior members 50 Rand per month. And that has kept SAFLI going. So we have been enormously grateful to the legal profession for keeping SAFLI going, and I think into the future it's certainly something. What I would like to see is that if we could, that the Justice Department or even Parliament get involved in assisting with legislation so that we were able to keep legislation updated, both in terms of point-in-time legislation, but as the legislation comes out of Parliament, that we were able to have a person employed to simply put the legislation up and keep it updated so that there was a central resource in respect of legislation that could be accessed not only on SAFLI but on gov.za as well as across all the ministries in the country, but so essentially across government and the three arms of it. That central database of up-to-date legislation, which I think is a very urgent need at the moment because we rely essentially on commercial production of it.
Justice.
Thank you, Commissioner. We have come, commissioners on the virtual platform. I didn't see any hand. I assume there is no one who has a question.
No questions, CJ.
Thank you very much. Thank you.
Thank you very much for the opportunity, Chief Justice.
Thank you very much, and you are now excused.
Thank you.
Thank you.